Good morning, ladies and gentlemen. Today, each of us will play a different role. I request you to please assume the role of a judge, hearing the case, and I assume the role of a lawyer, advancing arguments before you. The issue is whether judiciary can issue deadlines to the executive, whether judiciary can issue directions to the executive. This issue arose on account of a state of Tamilnadu versus Union of India, in which recently the Hon'ble Court held that a president is bound to accept or reject the bills within a period of 3 months, or else their assent is not necessary. They are deemed to have been assented. I submit you the legal position and finally my arguments and my prayer. Let us first consider Article 124(2). It says that every judge of the Supreme Court shall be appointed by the President of India under warrant, under his seal and signature. Naturally, certain qualifications are prescribed for appointment as a Supreme Court judge, like 5 years already having worked as a judge, or who has been in practice for 10 years. This criteria would be fulfilled by almost everybody. But the clinching or the final condition is that if he is a distinguished jurist in the opinion of the President of India. That means it is the prerogative of the President of India, by using his discretion, to appoint any person as judge of the Supreme Court. It's a wonderful, unique independence is given to the judiciary in India by the Constitution, by Dr. Ambedkar, who himself is a doyen of law and great jurist and economist, who was the chairman of the drafting committee of the Constitution, by stating that a judge is appointed by the President, but the President has no power to remove a judge. To remove a judge, it requires two-thirds majority in both houses of Parliament to propose the impeachment, and majority of the members attending and voting should also confirm the resolution. After that, if the President signs, the judge is deemed impeached. It is contained in Article 124(4). Article 130 says that the seat of the Supreme Court shall be at Delhi or at another place, but with the permission of the President of India. Under Article 138 and 139, Parliament has power to enlarge jurisdiction of the court. Like hearing of the appeals or issuing of writs, such as habeas corpus, mandamus, prohibition, certiorari, etc., to enforce the fundamental rights granted under Part 3 of the Constitution. Under Article 143, the President of India is authorized to seek advice of the Supreme Court, and the Supreme Court shall report its decision or its advice to the President of India. Under Article 145, the rules regarding admission of appeals and the timelines for making the appeals, and the rules as to the procedures to be followed in the courts are determined by the Supreme Court, but with the approval of the His Excellency the President of India. Rules as to granting of bails and rules as to stay of proceedings also have to be decided by the court only with the approval of the President of India. So far we have discussed the appointment and removal of Supreme Court judges. The power is given to the legislative and the executive. You can also consider the judges are impeached for two reasons. One is misbehavior, second is incompetency. These two are not such great qualifications. These two are the qualifications we judge any employee of a lower cadre. Misbehavior, even behavior and competency of the judges is kept under the purview of the legislative and the executive wings. Whereas the courts are barred from interfering with the proceedings of the Parliament under Article 122 and under Article 212, the courts are barred from interfering with the proceedings of the legislatures even if there are procedural errors. When we say the courts cannot interfere with the legislative proceedings even if there are dysfunctions, it means that under any other circumstances also, the judiciary is not supposed to interfere with the proceedings of the Parliament or the Assembly and the officers of Parliament and Assembly, namely the speakers. Now we have studied the judiciary is appointed, removed by the legislative and the executive, and the judiciary is not supposed to interfere with legislative proceedings under Article 122 and 212, even if there are errors. And the judiciary is not supposed to summon the executive to the court. Under Article 361, the President and the governors are not answerable. The word, please understand, they are not answerable to the courts for their actions in excess of their duties. It is so clear. Whereas the executive was given overriding powers over the judiciary. They appoint, they remove. Under Article 72 and 161, the President and the governors have the power to grant pardons, reprieves, respites or remissions of punishments, or to suspend, remit or commute the sentence of any person convicted for any offence by the judiciary. So judicial orders can be set aside by the executive, but the executive is not answerable to the Supreme Court or any judiciary under Article 361. No civil or criminal cases shall be brought against the President or the Governor during their term of office. And no warrant can be issued against them for their arrest. By this discussion, you must have understood that the judiciary has crossed its limits. In my humble submission, I say that the judiciary has crossed its Lakshmana Rekha. The judiciary is not supposed to impose deadlines or issue directions to the executive. As such, My humble submission is that the judges who delivered this judgment in the case of Government of Tamil Nadu versus Union of India are liable to be impeached.